the piece that stuck in my craw the most, and my soapbox is big today, is that a generation of sellers did not have to pay their buyer's agent when they bought that house that they live in and own today, but then want the ability to sell it, thinking then they want a law passed that their listing broker can't share their commission with a buyer's agent, basically making them more money. It's not right. You reap the benefits of this system. You weren't forced to. No one told. There's no gun involved when you bought your home, right? But there was a benefit that you didn't have to pay a buyer's agent to represent you, right? A listing broker did that, and now you're like, yeah, screw it, make the person buying my house pay one. I just think that's dirty. Welcome to another episode of the 121% Podcast. I'm Kevin Johnson here today with a new episode we're entitling Breaking Brokerage Inside Real Estate's Historic Legal Turmoil. And I'm joined today by Andrew Doyle, known as the agent's attorney with Seibane-Doyle here in Orlando, Florida, to discuss the big class action antitrust lawsuits that are currently facing the real estate industry, one of which has gone to verdict, others are pending trial. So welcome, Andrew. How's it going today?
I'm doing great, Kevin. Thank you so much for having me. This is some really exciting stuff. I'm a lawyer and I like to geek out on this. So thanks a lot for having me to talk about it. But it's however this stuff goes. It's in the news. It's in the media. The industry is already beginning to react. Everyone's kind of freaking out over it. No one really knows what direction it's going to go. So it's definitely something that bears worth discussion.
Yeah, so if we kind of look at the big picture here, we've got several lawsuits out there, and it seems to be, what's the lawsuit of the week recently. But what's at the crux? What's at the foundation or behind all of these actions that people are taking?
So all of these cases, including the major one that resulted in the $1.8 billion verdict, maybe trebled up to 5.6 or so, all of these cases really focus on what is referred to as federal antitrust law. Right. So the way I like to talk about antitrust is by going back about 100 years. Right. So if we go back to like the 1910s, 1920s, what we had were some markets, some industries that were developing, for example, the steel industry. Right. And if memory serves, it was the Carnegie family that kind of cornered the market on the steel industry. Right. One family that built a very powerful, successful business that created essentially a monopoly of that industry. So what eventually happened shortly after that was federal law came out that said, hey, it's just fundamentally unfair in the United States for one company to have so much power such that no one else can really enter the market. That's unfair competition. So they call that a monopoly, and specifically an unlawful monopoly. And as a result of that, we ended up with two pieces of law. The one that is at issue in these cases is known as the Sherman Antitrust Act. And that one basically says that it is unlawful to act in a way that suppresses competition. So it's kind of in that vein that we look at all of these cases coming up that affect the real estate market and commission sharing. But at the core of these cases, we're probably going to get into a few of them in a little bit. But at the core of these cases are these fundamental concepts of free market economy, fair competition, no restraints on trade, the ability to enter the market and be a market participant and have the freedom to contract and do what you're going to do without having unfair competition, costing you more money and suppressing your goals.
So it's kind of ironic that, if you listen to NAR on their side of the coin, it's their belief is that their practices and what's going on encourage competition, encourage exactly what the other side's claiming they're not doing. Right? It's a challenge. So let's talk about what are the big cases that we're facing, and what's at the crux of those. Like why do we have so many? Why can't it just be one? Let's talk about that for a bit.
Yeah. So, spoiler alert, I agree 100% with Nar's argument that the I don't believe that competition is necessarily suppressed by the NAR participation rule. I do think that technically the cases that we're going to talk about, they have pretty solid antitrust claims, at least in a vacuum. But I agree with NAR in essentially that I don't think we should be throwing the baby out with the bathwater just to solve this issue with when it comes to sellers commission. So I'm sure we're going to get into that in a little bit, but yeah, I mean, let's talk about the cases. One of the first one, I believe it was filed in 2019, so just before COVID, was
Mm-hmm.
the Moehrl case. That's Moehrl. That one was filed in Illinois, if I recall correctly,
Yep.
and it was filed against NAR and some of the other brokerages. NAR's headquarters is in Illinois, so I believe that's why that one kind of started it all. But I call that one the one that started it all. And the Moehrl case, that one basically tracks what we've been talking about, right? The argument is that NAR's participation rule and the claim that NAR and a group of other brokerages artificially inflated commissions. They allege the conspiracy there, and they said, hey, look, when you take NAR's rule, you take NAR's requirement that realtors be on the local MLSs, the requirement that the MLSs require an offer of compensation to the buy-side agent. All of this put together is a conspiracy, collusion that results in antitrust violations. And that's that one. That was the first one filed in 2019. I believe that one's set for trial coming up in spring of
March.
24. So that'll, yeah,
Yeah.
yeah, that one will be interesting.
But the funny thing, just on that, I mean, we'll see that thread through the rest of them, is that the word forced, required keeps coming up. No one's required to be a realtor. You can be a real estate agent, a licensee in any state, and not be a member of this organization. Then no seller is required to list their home with a realtor. They can choose a real estate agent. They can choose to do it on their own. They can choose to hire a realtor. And then they also can negotiate their commission however they want. There's no set commission. I asked our agents, have you been to a listing presentation yet where the seller didn't negotiate with you on your commission? And it was universal. No, we've had negotiations on every one of them. I'm like, so I don't understand. I mean, and I'm not an attorney, and my Louisiana public school brain, I don't understand the language of force required, because no one's going to these showings and we're putting a gun to the seller's head saying you must use a realtor and you must pay this and you must do that.
100%. So, if you really think about the way that these things work, right? One of two things happens when a listing agent, doesn't matter what brokerage you're from, a big brokerage or a mom and pop shop, doesn't really matter. When that listing agent sits across that dinner table from the seller and says, look, I'd be willing to list your house for a total commission 6%, and they sign it. One of two things happens. Either they understand that they're paying their listing agent 6% or whatever, fill in the blank, 5%, 6%, whatever. Or they understand the way that commissions actually work, at least here in the state of Florida, where listing agent gets that total percent commission, and then based on the offer of compensation on the MLS, the listing agent agrees to split that with the buy side. But contractually, the seller has agreed to pay their listing agent blank percent. And that
Mm-hmm.
doesn't change. It's not as if the buyer's agent enters the transaction and buyer closes, all of a sudden seller's paying more than they originally contracted for. It's just the
Mm-hmm.
question is just who gets paid what. And that decision is within the purview of the listing agent. So I guess my point here is I think all of these suits, the Moehrl case, the Sitzer Burnett case, and all the ones that are popping up all across the country, they all I think arise from this lack of understanding on the seller's side of how agents get paid, and they get very angry when they feel like they're
Mm-hmm.
paying for someone else to work against them. But
Yeah, and
to your
I
point,
agree.
I'm sorry, go ahead.
I agree, and it's the way I always explain it with our agents, and also with sellers, is that you've hired me to list your property, and we're, part of my compensation I'm going to spend, to market your property, whether that be through, professional photography, videography, drone work, staging services, whatever, at running social ads, Google ads. But one of the ways I market that is through what's called the multiple listing service. I will market your property using this distribution system, if you will, to other brokers that are members of this MLS. And if it's free for you to put it in there, but if they do, a broker comes along and has a buyer, and the buyer looks at your home, and the two of you, buyer seller, come to terms, a meeting of the minds, and they end up buying your property, then I will share my commission with them as part of the marketing cost. So, I was listening to Catchmark the other day on CNBC in the last call, where he talked about the buyer, and for those who know, Catchmark is the plaintiff's attorney in the Burnett case, that the seller is paying the buyer's commission, and they're being forced to. I mean, that's just simply not. They're not paying it, and they're not forced to do that at all, right? They're not doing it, and it's so frustrating that there's just Again, he's an attorney, and I know I kind of agree with you on the position of the attorneys here, but that's just a fundamental misstatement of the facts from the lead plaintiff attorney, in my humble non-attorney opinion.
Well, let me give a qualified agreeing opinion. One, I'm not licensed in Missouri, which is where the Burnett case. We can just jump into the Burnett case now because that's the next one on the list anyway. But I'm not licensed in Missouri, so I don't know how things are done in Missouri, but I would imagine they're roughly similar to the way they are in the state of Florida. And in the state of Florida, you're 100% correct, right? Like we said, the commitment from the seller is to pay 6%, and how that 6% is divided is within the purview of the listing agent. And if the listing agent decides to offer 3%, it should be part of the listing contract, which it is. But that's the listing broker's prerogative. The seller has committed to 6%. Now, to the point we were talking about a little bit ago, right? They're being forced to pay 6%. They're not. They're not being forced. They could look at that listing broker sitting across from them at that dinner table in their home, following that listing appointment, and say, "I'm not going to pay you a dime above 3%. I'm just not. 3% is my max. So if you want to take that listing for 3%, and if you're telling me that at 3% it's going to get no love on the MLS, fine. Take that 3, divide it by 2, offer 1.5 each side, and sell the property. But I, as the seller, am not going to pay more than 3%. That is negotiation. There are some brokers out there that would take that listing at total 3%. There are some that will say, "Sorry, I'll pass. My cost is too high. I'm going to put too much into it." There will be negotiation back and forth. But here's the crazy thing. We live in a country where we have a free market economy, and capitalism drives it's a capitalist economy, right? So what's going to happen, right? When you have that rich negotiation, you have those hardline sellers that are just going to dig their heels in and say, "No, well, guess what? That 3% listing will then go to a small player that has a lower cost, overhead cost." So that actually allows for greater competition. So I think that at some level, the arguments in these cases, although I do believe that they are technically, legally, and factually antitrust violations, I feel like we're throwing the baby out with the bathwater when we say, "Well, we got to completely upend this commission system because it takes advantage." We have a law on the books that the lawyers were able to put together a solid case for and get a monster verdict on, and that's in the Burnett case. But how we go from here as an industry, as a country, I think it's important because there are significant ripple effects that I think actually far outweigh the 3% on any given home sale that a seller is going to incur, and we can talk about those.
Yeah, definitely. So before we dive more into Burnett, let's talk about this. So there's 3 other big ones. There's a couple other ones that are more recent, but the Gibson and Baton 1, Baton 2, how are those, from a legal perspective, like, are they structurally basically the same? Are they different? I know it seems like one of the Baton cases is coming at this from a different angle, or is it the Gibson case? I forget. It's coming at it from a completely different angle.
I believe it was Baton. I call it Baton. I don't know if it's Baton or Baton, but I believe it was Baton 1 that was brought by the home buyers.
Yeah, it is. Yeah.
So all of these cases, most of these cases are brought by sellers against brokerages and NAR, alleging the conspiracy. Baton 1 was, if I recall correctly, out of New Jersey. And that one was brought by home buyers. And they were saying basically the same argument: antitrust violations, collusion, conspiracy, so on and so forth. But the judge in that case had a problem with the analysis. And the problem that the judge had in Baton 1 was, you're the buyer. You are not the seller. And because you're not the seller, you're not paying for someone else's commission. You actually are the indirect purchaser here of the services rendered by the brokers. And because you're the indirect and not the direct purchaser, I'm going to dismiss this case. And the motion to dismiss was granted. And if I recall correctly, the procedural posture of that case is that they filed an amended complaint, and that one's just kind of moving forward. But to distinguish that one from the other cases, Baton 1 was brought by home buyers. And the takeaway from that is the trial judge had a fundamental problem with taking this seller claim and really morphing it into the buyer realm. So what I find interesting about Baton is that in some ways, the trial judge in Baton gives credence to the arguments made in Moehrl and Burnett and Sitzer. Essentially, the judge in Baton is saying sellers are paying the commission, which again returns me to the point. Even this trial court judge is, I got to watch myself here because I don't want to call this judge out, but even this trial court judge is using this confusing language to articulate the reasoning in the opinion granting the motion to dismiss. Put another way, this trial court judge is saying sellers are paying the commission for both agents. That's fundamentally not accurate.
Correct. But the problem with that is, and I think part of, this is a case of the industry making its own bed, is that you have leading franchisees out there that put out a script book that said, Mr. Buyer, you don't pay my commission, the seller does. My services are free to you. My services aren't free, and the seller's not paying. It's a fundamentally incorrect, but that was introduced as evidence at court. And then you have agents, who many of them meaning well, having conversations in Facebook groups and such, wanting to debate the nuances of wording. And it's like, no, fundamentally, right, the seller pays the listing broker can share that commission with buyer's broker agent, right? Well, but the buyer's paying for it because they're the one you're trying to get semantic, but legally structured, the money flow is seller pays. Right? Yes, there wouldn't be a sale without a buyer's income or money being paid to the seller, but then from that the seller gives. Right? So we made our own bed in a way, and that's where I try to tell agents all the time: words matter in everyday life, but they really matter when you're talking about one of the largest, if not the largest, financial transaction in people's lives. Details matter, and it's so important. Brokers need to step up and train agents better, and agents need to step up and make sure they take some personal responsibility to educate themselves and know the facts and not just get colorful with language.
I agree 100%. If I were to be asked, who do I think is in the best position to fix this or reverse this or clarify the confusion that buyers and sellers have in the transaction as to how the brokers are getting paid, I would say the brokers are the ones that are in the best position. What is the actual training going on from the managing broker level down? I don't even look to corporate, true corporate parent policies, because a lot of these major targeted brokerages, they're franchises, right? So I can't expect a corporate parent of a publicly traded company to have policies that are fulfilled, that are drafted, followed to a T all the way down to the individual transactional level, I think that's unreasonable. So it's the boots on the ground brokerages that really need to be training their agents in a way that makes sure that there's a lot of transparency on the sell side, and avoid these misstatements, because I agree, it is a misstatement to say that
Mm-hmm.
my services are free. They're not.
And then again, I don't think anyone
Um,
did it with malicious intent, right? But
Agreed.
it was more marketing spin, and a lot of them were just educated wrong. They didn't have brokers that really, took the time. Like in Florida, if you're a transaction broker, they're customers, not clients. That single agent. You have agents that use customer client interchangeably, not understanding the significant legal impact that can have on a lawsuit coming down the road. So Paul,
No.
you got side rail there. Um, so yeah, what about the Gibson case? Because everybody keeps talking about that's one of the behemoth ones.
Yeah. Gibson is a big one. Gibson is the one that has this massive scope. And by the way, these are
Mm-hmm.
all class actions cases, right? So they're all brought by a large category, a large number of plaintiffs, usually sellers, with the exception of Baton one, that are alleging similar claims and similar damages or losses, right? So that's what a class
Mm-hmm.
action suit is. Gibson, the class is expanded. And if I recall correctly, the class in Gibson is all plaintiff. The class includes all sellers who sold a home that was listed on the MLS between October 31st, 2019,
Mm-hmm.
and the date of filing, that used the services of one of the named defendants, and those are the large brokerages. Off the top of my head, I don't remember what they are. I think don't remember exactly what those brokerages are, but I think they were different. Compass,
Yeah.
EXP, Redfin. So these are different brokerages than were targets in Moehrl,
Mm-hmm.
and also different brokerages than were targets in Burnett and Sitzer as well. So, you know, basically we had Moehrl, that one's still pending trial. We had Sitzer and Burnett, which we actually kind of skipped over. That one is the big one with the massive verdict in $1.7 billion. And then Gibson said, you know what, we're going to go after everyone
Mm-hmm.
and include in that class. I think estimates of the total damages in that one are pushing $200 billion, which is what, 100 times a 100x multiplier on the
Mm-hmm.
damages on the base value damage awarded Burnett. So
Yeah.
obviously that one's
And
trending.
it, and if you and if you treble that out, because I think it was almost 300 billion. It was like 200, high 200s, right? And so you treble that, you're looking at upwards. You're
Yeah,
knocking on the door of $1 trillion in damages. So yeah, so
that one's
Sitzer
a nice.
Burnett. Yeah, let's dive deep on that one. Um,
Yeah, that's a good one.
First and foremost, so
Fun one.
we're at verdict, right? That one's done. We There were two defendants that did settle, and those settlement agreements are moving forward. So they were kind of pulled out of that. That's Anywhere and Remax. Um, but as of right now, right, the defendants have vowed they're going to appeal. So, what are some of the possible grounds for appeal in the Sitzer Burnett case, and how likely do you think they could succeed in something like this?
So for me, what jumps out to me as a trial lawyer is really two strong bases of appeal. One is that the jury just acted unreasonably, in the sense that no reasonable jury could have awarded the damages or have arrived at the verdict that this particular jury did. Without, having reviewed all the trial transcripts and all the documentary evidence, I don't see that as a winning argument, in my humble opinion. And a lot of that has to do with the fact that when I look at the claims, the fundamental claim of antitrust of an antitrust claim under the Sherman Antitrust Act, and I look at the conduct, again, I don't think it was intended to be bad conduct. I don't think that there was malintent here, but
Mm-hmm.
there do seem to be, collusion, conspiracy. They have a dirty tinge to them, right? They're dirty words, right? We think of people acting badly, but that's not technically what's required. You just need to work together to a goal that harms other people. And think that seems to be what happened here when you put all the pieces together. You've got the non-participation rule, you have the MLSs deploying, you have the brokerages participating in it, and all those pieces come together to result in the antitrust violation. So I don't think that the verdict is likely to be overturned on that basis alone. If I'm being, Florida trial lawyer looking at this case, I think that the piece of evidence that probably hurt the defendants the most in Burnett was the admission of evidence comparing the United States commission structure system with that of other countries. And there's a geeky legal reason for that. There's a threshold bar for the admissibility of evidence that's in basically every jurisdiction. Here in Florida, it's relevancy, codified by Chapter 90 Florida statutes. And the standard test for relevancy is whether or not the evidence is, if it tends to make a material fact in the case more or less probable. What's material in a case about commission structures? A lot. The corporate practices, right? What's in the documents, whether or not things are disclosed. What may not be material is what's going on the other side of the pond. Why does it matter what is going on in the UK or in Australia? Who cares what Australia's commission rates are? Why does that make what these defendants allegedly did more probable? How does that bear on that? So my understanding is that there was a significant amount of discussion in the case before the jury about how the U.S. standard commission rates of 5 to 6% on average compare to rates abroad in other countries, other established first world countries like the U.K. or Australia. You're looking at 1%, 2%. You're looking at materially different things. But guess what? From a macro sense, it's a materially different economy too. It's a materially different housing market. Kevin, I don't know if you watch a lot of HGTV, but
Yeah,
I do.
I used to.
So I watch a lot of HGTV, and I like to watch House Hunters International, right? It's just sort of that mindless show. And the international one always gets me because I always see these people coming from the US, going to France, and where are they living, right? Or Germany or the UK, and they're looking for this loft in the middle of London or something like that, right? And they're looking, but they're not looking to buy it. They're not buyers. They're tenants. They're renters. So I did a little bit of research, not enough that I would say, we should use as a data point to compare the two. But it jumped out at me that these markets tend to have more robust rental markets than we do in the United States. So what I think happened in the Burnett Sitzer case, at least to some extent, is there was an apples to oranges comparison with no contrast. And in addition to the potential admissibility of irrelevant evidence, I would assume that evidence was objected to by the defendants. I don't know if it was.
It was,
but
there was an article I read about it.
Sure. So then there you go. I mean, that's kind of like a law school 101 objection. Like that just jumps out to a lot of trial lawyers. So I feel like that's probably one of the strongest points of appeal is this jury heard irrelevant evidence comparing the U.S. market to markets abroad, and then made a comparison and rendered a verdict ultimately that was the result of hearing and receiving inadmissible evidence, irrelevant evidence. And there's a lot of other evidentiary arguments that kind of come with that. Some of those were probably raised, but that's the one that jumps out to me. Is this jury decided this verdict in Missouri for the United States based on what's going on across the pond?
Yeah, so the jury came back. They did their damages. It's just a financial award right now. But the big question is, and NAR put out a video that as of right now, there's no, injunctive relief, nothing requiring behavior changes or anything like that. But what shocked me, and again, not an attorney, was that could still come from this case, even though the jury's done. The jury was only charged with just the financial award, that the judge could still come down with other type of relief for the plaintiffs, And then also now, today, the DOJ, is working with the plaintiff's attorneys now as well to look at action that way. So what else could come from just looking at this one case? What are some of the potential reliefs they could get beyond financial?
Sure. So the Sherman Antitrust Act and antitrust law, federal law, has two types of relief built into claims that are brought under it. One is monetary relief, compensation, damages, which is what we have here, 1.7 billion that could be trebled or tripled up to about 5.6 or so. That is a jury question, in addition to fundamentally whether or not the defendants actually committed any antitrust violations. They answered all those questions in the affirmative. They arrived at the dollar value. Jury's done. Now, federal antitrust law empowers a court to offer or to provide what's called injunctive relief. Injunctive relief is not money, but conduct. So when you ask a court to provide injunctive relief, you're asking a court to say, tell these people or these companies to do something or to stop doing something. So under traditional antitrust, you have prohibitive and you have structural relief when it comes to injunctive. Prohibitive is exactly what it sounds like. You are prohibited from doing X, Y, and Z. Possibility, we may see some ruling, which I can guarantee you is probably going to be appealed. But for example, one of the forms of prohibitive relief may be, NAR, you are prohibited from requiring an offer of compensation to appear on an MLS listing. That would be prohibitive relief. The other form of relief that we commonly see here is structural, and that really speaks more to the monopolistic element, right? When we go back 100 years and we talk about busting up the monopolies, structural, it would actually require a restructuring of the company that held the market power. So I think we're a little bit less likely to see structural relief and a little bit more likely to see prohibitive relief. The scenario where I think we may see structural relief is when we talk about NAR's ownership of local MLSs. That may be the restructuring that we see, where we're no longer going to allow or permit NAR to actually control transactions that much at the local level. They would remain a trade union.
Yeah. One of the interesting things in the Burnett case was, the Anywhere Real Estate, which owns several real estate brands, and then Remax opted early on to go ahead
Smart
and
move.
settle. And right, that's my question, right? It's like they were mocked in the industry for cowtailing and giving in, and but now that we have a judgment, whoa, okay, maybe they're a little bit smarter, because I think the Anywhere number, don't quote me, 85 million. For example, there's like 55 for Remax, but that's for the Sitzer, Burnett, and Moehrl, right? That's both of them. And it's part of the reason I'm segueing to that is part of that, there was some agreement of some, not just financial, but here we're also going to do this now where like both companies have said now their franchisees will no longer be required to be members of the National Association of Realtors. And then there was some additional things that they agreed to do at their company-owned brokerages, like no longer requiring an even split of broker and the listing brokers commission for the co-op, making an even split, and a couple other housekeeping type items. Is that the type of stuff? Hey, well, first, kind of, what's your thoughts on the settlement? And then two, is that the type of relief you think we might start to see? If the plaintiffs were okay with that relief, that might be a tell of what they're looking for the judge to do, broad scale.
Yes to the second question. I do think that it's probably the canary in the coal mine. This is probably the direction that this class of plaintiffs are looking for. They're looking for structural and procedural changes at the brokerage level. Basically, rather than have the court order that sort of relief, get it through agreement and commitment in the settlement agreement. That is customary. A lot of these antitrust cases and these similar conspiracy, collusion cases, they also pop up in the financial industry involving banks. And
Right.
we see that a lot as well, right? Where the monetary relief comes, but really the case is brought to change the industry and curb the practices for whatever public purpose or public benefit. So yeah, I mean, I think that the type of relief that was uh, arrived at in those settlement agreements is probably a good indicator of what they're looking for. That said, judicial discretion is a real thing, and the judge may hear the plaintiff looking for one thing or seeking one thing and give them exactly what they're asking for, much more, or much less. It all
Right.
depends. But to your first question, if we can, I'd like to geek out about this for a second because I love
Yeah.
this idea.
Yeah.
So I got a
Love
saying that I use a lot in practice with clients, which is practical over principle. And practical over principle, for me, that is a practice maxim. I
Right.
love to live by the practicality because principle is emotion, right? If you're fighting for something based on principle, it's not because you think you're going to win or you are looking for compensation. You're fighting because you're angry, frustrated, hurt. Those are emotions. Emotions don't really have their place when it comes to level-headed business decision making. So, when I look at Anywhere and Remax settling this case, and they settled before trial, I think that those were very wise decisions by their trial counsel, and they're saying, look, there's very real potential exposure here. Keep in mind, those attorneys, those law firms that represented those brokerages, those defendants, they were in this case for a long time. This case has already gone through discovery. There were depositions taken. Most importantly, there were, I don't know if they were agreed, but there would have been significant exchange of information as it relates to the total damages that these plaintiffs were seeking. So putting myself in the shoes of trial counsel for Remax, for example, Remax is staring down the barrel of sharing in a part of a judgment that they know is probably going to be in excess of $1 billion. And the reason why that 1,785,000,000 and change, that's not an arbitrary number. That's not just a number that the jury just, picked out of thin air. That I believe that is an exact sum of each and every out-of-pocket buy-side commission paid by all of the sellers in the aggregate. And I don't know how many sellers there were, but I would imagine it's probably in the thousands that were part of that class. So it was a very specific number. That number was floating around between all these attorneys for a very long time before this case went to trial. So when a defense attorney, and I'm often on the defense side representing businesses, when a defense attorney is looking at going to trial, it's not about necessarily only, am I going to win? Because there are variables. Variables are, what's the credibility of the evidence I have? More importantly, what's the evidence against me? And what is the jury looking like? In this particular case, Missouri, I think that there was a potentially unfavorable jury pool for these defendants from the very get-go. So if you want to follow me on this, this case was brought in Missouri. Missouri is the breadbasket of the United States. Primarily blue-collar workers and small business owners. A lot of pride in home ownership there. But we're talking about a materially different market than, say, Miami, LA, Portland, Seattle, New York City. We're not talking about one of the most affluent metropolitan areas of the country. These are people that are the backbone of the United States, right? So when you pick a jury in Missouri, right, and you bring this case to those Missouri jurors, you're getting a random cross section of what is more than likely Missouri homeowners, and they're hearing one attorney stand in front of them for 2 weeks and say, if you don't agree with my sellers, you may end up paying the buyer's commission when you sell your house next year. I don't think that those are the words that were ever used. That would be what's called a golden rule violation, and probably never. But that was the message, and I think that was crucial in Anywhere and
Mm-hmm.
Remax's wise decision not to proceed with trial and to settle pre-suit. That hindsight is 2020, but look at that.
Yeah.
85 and 55 were the respect 85 million, 55 million respective. I mean, what's a proportionate share across the defendants of 1.6 billion? Way more than 85 million all day long.
Or
And they
treble.
settled two. They got 2 for 1.
Or
Yeah,
treble at almost 6
or
billion.
treble. Yeah,
Yeah.
yeah.
So I mean,
So
it's
I think it was a great decision. It's a ton of money, but I think that was the practical decision.
well, also you have to look at the cost to take it to trial and go through trial, and then the inevitable appeals. All of that cost that they're now, not going to have to incur. There's a finite end to the bleeding, if you will. They put a tourniquet on it and stop it, and as part of that deal, I know at least on the Anywhere side, it also protected the franchisees, I'm sorry, and their agents. So there was some extension of protection in that as well, which was good. So,
Yeah,
you
without
know,
question.
as we move forward and kind of think about the future now, what are some of the big impacts you see in our industry, like specifically in the area of commission structures, and then also we can talk about that, home buyers and sellers.
Okay, so we're getting into some speculative territory, but I've actually spent a fair amount of time, quite a bit of time, kind
Mm-hmm.
of just theorizing about where this could be, right?
Mm-hmm.
So everything here assumes that sellers, the plaintiffs, get their way, right? A change is made.
Mm-hmm.
Buy side commissions will no longer be baked into the purchase price of the home, right? So let's take the 5 or 6. 6 is a round number, so let's just take 6% and say, okay, that means that dividing things down the middle, all things being equal, it's a 3% average list side commission. Great, they save 3%. Do they? Do they? If I'm a listing agent and I now am dealing with potentially unrepresented buyers, right? Because if the seller doesn't pay the commission, and if you're only listening to this via audio, I'm using scare quotes here. If the seller, quote unquote, doesn't doesn't pay, quote unquote, the commission for the buyer has to come out of pocket to pay for their own representation, which is in and of itself a major problem. Query, Kevin. You're in real estate. You're killing it, right? Your brokerage is killing it. How many first-time home buyers that get like an FHA mortgage, say, they're paying what, 3.5% down,
Mm-hmm.
right? A stat I saw said that the average median home price in the United States recently is like $431,000. So 3.5% of 431 is about a $14,000, give or take, or so down payment. That's a lot of money to come out of pocket down payment. But people save and they budget and they are smart with their money for the 6 months leading up to save for their down payment.
Mm-hmm. Yep.
What buyers don't do is count on paying another 3% of the purchase price to have representation in that deal. So in many ways, the potential cost for a buyer to enter the homeownership market will double. Their down payment, best case, 3.5%
Mm-hmm.
plus 3% buy side commission out of pocket,
Plus
um,
closing costs. Plus closing costs.
plus closing costs, right? So that assumes sellers, so to speak, get their way and they're no longer coming out of pocket on their net proceeds to the buy side commission. See, I'm even doing it myself. I condemn others for confounding those terms, but for illustrative purposes, that's what we're getting at, right? I
Mm-hmm.
think it goes even deeper because when you take any individual buyer, it's a busted
Mm-hmm.
deal, right? They don't have the
Yep.
down payment, they can't close, whatever. Maybe they lose their deposit. That's terrible for them, but extrapolate that out 50,000 times across the state of Florida,
Mm-hmm.
millions of times across the country, right? We're
Mm-hmm.
looking now at a barrier for entry for middle income homeowners to get into the homeownership market. We're looking at a shift from home ownership to rental. So maybe that was the
Mm-hmm.
whole goal, right? That gets us to the UK market, where we're
Right.
primarily a rental market. Maybe that was the goal. I don't know. But I have very legitimate fears, and obviously I have very strong feelings about what effect this may have if homeowners end up being priced out of home ownership. I'm sorry, buyers end up being priced out of home ownership because they can no longer afford representation. They just simply can't pay out of pocket. The other thing that may happen is listing agents are going to have to work more, because if you have buyers that can't afford their representation, well, you're still a listing agent. You still have the same obligations you had to do. You had to get the property, you had to take the photos, you had to do everything. But guess what? Now, when you have an unrepresented buyer come to you, what do you reasonably expect that contract offer that they submit is going to look like? It's probably not going to look like the form contract that you have access to in your proprietary software through the MLS on Form Simplicity. It's not going to be a FAR bar as is. It's going to be an older version, something they find on Google, maybe something from a different state. People are going to start
Chat
playing lawyer
GPT.
themselves. Chat GPT. Yeah, I mean, that's an inexpensive option, $20 a month. But there are a lot of micro issues that will cause macro problems. And I think really, if to kind of bring it full circle to NAR's counter argument
Mm-hmm.
in Burnett and Sitzer, the system provides greater access for home buyers. I think they actually argued that
Mm-hmm.
the current commission structure provides first-time home buyers with greater access to enter the homeownership market, and it actually increases competition. So,
I would
like I
agree.
said at the beginning, I agree with NAR's position there, even though I think ultimately the jury was probably right on these facts applying the law. There probably were antitrust, but we're throwing the baby out with the bathwater, because what
Yeah.
we end up getting is potentially significant economic issues down the road.
I mean, you think about, we're the largest driver, or real estate, the largest driver of the U.S. economy, and now you're going to mess with that. A couple of the points that just amuse me, or irritate me, I guess. I say amuse to be positive, is that first I'll go back to the attorney for the plaintiffs and Burnett, saying that he thinks that the buyers will be able to save money on that purchase, right? The purchase price will be lower. And that's just a fundamental misunderstanding of how home market value works. That's not a consideration. So whether or not there's a commission, the market value, the appraiser, when they go out to determine market value, goes, is a commission being paid? Because that'll affect the value of the home. That just doesn't happen. You're going to have, I absolutely believe it, agree with you, you'll have buyers going directly to listing agents and unrepresented. And my concern with that is like being unjustly charged with murder because the prosecutor thinks you did it. And then the defendant saying, you know what, Your Honor, I don't need an attorney. The prosecutor is a really nice guy. He said he'd represent me. I think he's got my best interest in heart. I mean, that's what
Yeah.
we're putting buyers in the position with the largest financial transaction of their lives. You talked about down payment money. The buyers that we're seeing today struggle to come up with just the down payment and closing costs. Typically, they're getting gifts from family, especially on FHA, or they're using some type of down payment assistance. And now we're going to ask them to come up with even more money. They don't have the money. Like we tell them, look, make sure when you get your inspection report, you want to have some reserves, some money. So if they say your AC has 2 years left, 3 years, well, make sure you start saving money for roof replacements, all that. They don't have that to walk out the gate with. Now we're going to want more money from them. And then just the piece that stuck in my craw the most, and my soapbox is big today, is that a generation of sellers did not have to pay their buyer's agent when they bought that house that they live in and own today, but then want the ability to sell it, thinking then they want a law passed that their listing broker can't share their commission with a buyer's agent, basically making them more money. That's it's not right. You
Mm-hmm.
reap the benefits of this system. You weren't forced to. No one told. There's no gun involved when you bought your home, right? But there was a benefit that you didn't have to pay a buyer's agent to represent you, right?
Mm-hmm.
A listing broker did that, and now you're like, yeah, screw it, make the person buying my house pay one. I just think that's
So
dirty. That's my opinion, but and I'm not an attorney, and I'm not pointing at anyone, and I don't get sued. But like, that's just wrong.
no, I would agree with that. That's an interesting thought. That wasn't one that came to mind. Another criticism that I hear a lot, as I teach classes and talk more to market participants here in Central Florida about this is, well, can't buyers just borrow the commission,
Oh,
right? Can't the
that's
lender
oh
just,
yeah.
right? Mind blown.
So
Uh, Here,
let's
you want me to
finance
take
that
this?
3% over 30 years. Really?
Right. So that's the financial cost, right? So right now interest rates are through the roof, 8%, 9%. Who knows what they are? Maybe they're 7. It doesn't matter, right? It's gone are the days of 2 points, 3 points on a mortgage. So
Mm-hmm.
you're going to be financing that $14,000, but before you can even get to the point where you are financing that protracted over the course of 30 years, the lender can't lend on the commission. And the reason for that is the fundamental purpose of a mortgage. Here in the state of Florida, it's different in other states, right? But here in the state of
Mm-hmm.
Florida, a lender issues a mortgage to secure their collateral, their house. The collateral, the house is what they get if you don't pay. And what they need to know, this whole loan approval process, is all about whether or not that house is going to be enough to repay that lender
Mm-hmm.
if you don't pay your mortgage on time. So that's the purpose of an appraisal, is the assurance that the lender has a collateral that's worth what they're owed over the course of the next 30 years at the time they loan the money. So the only way, hold on to your hats, the only way that it would make any sense for a lender to lend on the commission is if the property appraised 3% higher than the purchase price, or whatever amount of that commission was, which we have to assume is going to be 3% of the purchase price, right? So that means that, when was the last time, Kevin, you saw a closing come through your office where you got an appraisal that exceeded the purchase price, let alone by 3 percentage points?
It's rare. It happens, but it's very, very rare, and
Yeah.
not by that
It
much.
happens. It happens when the property is underpriced to begin with.
Right.
But no
Yep.
seller wants to sell themselves short to price it low to attract attention. They price high and then hope for a bidding war. So, you can see, like, the issue here is what the sellers want hurts the buyers. And if the buyers give the sellers what they ultimately want here, right, we end up with the same problem. It just shifts. It's a tennis match. It goes back and forth. It's ping pong.
Mm-hmm.
You're insert cliche, throw the baby out with the bathwater, right? We're gonna have a problem no matter what, which is why I have looked at these cases from the very beginning and said, it's a wheel that is not broken, so why are we looking to fix it? That's
Yeah.
that's my overall take on this.
I go back to what you said earlier. What I said and you countered is, the real estate industry as a whole made this bad, and it's up to the real estate industry to fix it. It's having a higher, and this is the challenge where NAR comes into, right? Is that they want membership, they want the dues, they want to grow as an organization, so the standards are lower, right? So they can have membership. There was a story where I think it was actually when Bob Goldberg took over at NAR several years ago, where his first meeting was in the morning about, we need higher standards. We need to, really crack down on our industry and hold our industry accountable. Break for lunch, afternoon session. We need to drive membership. What do we need to do to get more members, right? So you have a dueling battle of elevating the profession, but yet maintaining membership and growing. You cannot elevate the profession and have stricter standards and hold people more accountable and still grow the base. It's just not going to happen. So you have to then make a philosophical choice. Which one's more important to you, the dollar or your reputation? And as long as, in my opinion, they continue to choose the dollar over the reputation, we're going to have a challenge. And that's where we get to a lot of these, misstatements, lack of education with agents, people trying to split hairs to make marketing points, saying, my services are free to buyers, that type of stuff. We're going to continue to have these problems. So I know we're kind of hitting the time limit here. and I really want to give you a chance to talk about something that I know that you're probably not going to say much on. But what are some of the challenge or misconceptions? There's a lot in the media. I've watched, especially in preparing for this talk with you, I've watched countless news stories from local markets across the nation and local reporters, state reporters. Like I'm going like, oh my, and then them interviewing agents that both of them are clueless um, about the reality, right? What are some of the misconceptions that you see, or misinformation, or grumblings and complaints, and that you've heard that you take issue with in our industry over these lawsuits?
So the biggest one is that the lawyers created the problem. Um, the lawyers didn't invent the facts. And while maybe philosophically I disagree with the position that the plaintiff's lawyer took in that recent interview, I think it was with Inman, right? Um,
Oh
was
no,
that the one
he
you're
was
jesting at?
no, it was with he backed out of that one. It was
Oh,
with Last Call on CNBC.
okay. I disagree with the position that he took there, and the argument that sellers paid the buyer's commission. I don't agree with that, at least not here in Florida, based on the way we do. That aside, I don't think that he and his legal team created the problem by bringing this case. And I don't think the plaintiff's lawyers in all of the other cases created the problem. The facts are there. In all of these cases, they're there, right? The law predated the filing of these lawsuits. The antitrust law has been on the books for 100 years. They didn't invent something just to make hundreds of millions of dollars. But I've seen it already. Local Facebook groups are blowing up, condemning these lawyers, saying they're all about the money. And no lawyer engages in class action lawsuits and sustains them simply, gratuitously. That
Mm-hmm.
said, it is a to move that type of matter forward. It's an all hands on deck. Everyone in that firm is committed to that case. They don't have hundreds and hundreds of cases in those firms. They have like 30, and they may have a staff of 100 spread across a couple different offices, right? These cases require so much time and investment, but they also require so much skill, knowledge, expertise. And then, perhaps most importantly, they require an enormous amount of financial investment. The sellers in those cases, be it 200 or 20,000 or 200,000, or who knows how many homeowners in Gibson might be involved in that case, they're not fronting the cost for that case.
All right.
They're not.
Yep.
Those lawyers are financing the cost of litigation, and don't be fooled. Everyone in their office needs to continue to get paid. There are experts that oftentimes need to be retained and paid enormous amounts of money for their time and testimony, which they're perfectly entitled to require. Simply the cost of getting a transcript from a deposition may be $10,000 if the deposition lasted 3 days long. Just one person's deposition, you may have 30 people
Mm-hmm.
deposed over the course of 2 years. So it's not unreasonable to look at this case and say there were millions and millions of dollars of litigation costs invested into bringing that sort of case to fruition
Mm-hmm.
before you even got to the first day of trial. And
Right.
then when you do get to the first day of trial, it's all hands on deck. Everyone in that firm is focused on that one thing and playing their role. The overall cost here, while it probably does not approach what the 25, 33, I don't know what the contingency fee on that case is, or even if they're actually on a contingency fee, although usually they are, it doesn't approach what they would get in terms of a third of a tripled damage verdict. But, that's a lot of money to invest. And then the other point I want to make is they don't see a dime for a long time. Those attorneys will not see a dime on this unless there's a post-verdict settlement where money actually changes hands. It's not like the Burnett jury said, all right, $1.7 billion, time to open up your checkbooks.
Write a check on the way out. Pay the
And
cashier at
you
the
write a
exit.
check on the way out. It doesn't work like that. NAR is appealing right? They made their notice of appeal. I don't know if they've officially filed their pleadings yet, but that takes time. That has to hit the appellate court. That has to be, there's a reply brief. There's a lot of stuff. This may go on for years before those attorneys that ultimately won this $1.8 billion verdict will ever see a dime on that. But guess what? They fronted the costs of that litigation. So, my personal sentiment is I think the attorneys are catching a lot of flack here, and I guess the takeaway here is a little bit more moderate. I think that fundamentally it makes little sense to bring these type of lawsuits pop up across the country that change an industry, because I think the economic impacts that we're going to see are worse than the net cost to sell a home. But I do think fundamentally these cases have merit. I think that they do have teeth to them, and I don't think it's the lawyers to blame.
Yeah, I mean, I said earlier, I don't blame the attorneys either. I wish they would have done it, right? I mean, I wish that our industry too would be a little bit more accountable to themselves and holding agents more accountable. We catch a lot of flack because we do follow the rules and follow the law. And, I've had agents get really, angry with us on deals because we're following the law. This is what it requires, but this is the way I've always done it. So I'm sorry. I mean, I appreciate that. And thankfully we came along to help you in your ways, I guess. I don't know, but
No.
it's frustrating. It definitely is. And, I think, in my opinion, and again, just my humble opinion, we're going to see a reduction in agents in the United States, double-digit percentages. I think it's a good cycle. I think we've got a lot of folks out there that, don't sell anything or sell maybe one a year, two a year, that aren't going to stay in. And it's going to help elevate our profession. And though there may be some turmoil, as we mentioned earlier, I think we're going to come out of this a better industry, a more educated industry, a more customer-focused industry than we've been going into this. And I think brokers are going to level up. I think agents are going to level up. But we got to get through it first. So if we go back to our title, breaking brokerage, I think some folks are trying to break brokerage, but I don't think it's going to break in the end. I think we're going to become bigger and stronger and be able to serve our customers even better in the future. So I'm not sure what your thoughts are.
So I think that we're going to see an increase in transparency, whether that comes as edict from the powers that be in Congress, or administrative agencies, or DOJ, or the judge in the Missouri case, or personally, I think we're going to begin to see the industry police itself at a more local level. And here in Central Florida, we already saw that when on November 14th, I think it was, Stellar MLS said, look, you used to have to offer $1 to the buy side. There had to be an actual dollar value. And now NAR has amended its participation rule that did not require an actual dollar amount, but just that there be an offer, but that it would not be a violation of the participation rule if that offer were zero. Stellar has brought that into the system, and now it is permissible for a listing agent to offer $0 on the MLS. Doesn't mean the property is going to sell, which is a whole separate issue, right? Questions of steering and whether or not buyers agents are going to properly show those properties, but perhaps a conversation for a different day.
Well, I mean, you see it in groups all the time where people are complaining. They'll show pictures of the offer of comp and go like, and then you'll see comments, good luck getting that one shown. I'm like going, A, it's wrong that you think it, but then you put it in writing in the public.
Right. Yeah, no, so the funny thing about steering is that it requires the intent, right? It requires bad intent. In order for an agent to be responsible or legally culpable under the steering statutes, right? They have to intend to avoid the property and instead direct the buyer to properties that have higher commissions, where that buyer's agent had a greater pecuniary gain by encouraging that buyer to purchase that property as opposed to the other one. So the hardest thing about intent is, how do you ever prove what's in someone's mind? The best way to prove it is to show that they wrote it. So when an agent posts that sort of sentiment publicly, who knows what would happen down the road? But I agree. It's morally bad that
Mhm.
that you think it, but perhaps not an exercise of good judgment to publicly post it either, because that may come back to haunt you. But yeah,
You're right. You're
I
right. The
do think.
Stellar. Oh, sorry. Good.
No, no, go ahead.
Stellar. The Stellar move. I applaud it, and I will say kudos to Anywhere Real Estate, who was the first major brokerage franchise group to come out a while ago to say that they wanted this. They wanted to see this move. That the difference between $1 and $0 is stupid, and or they use the word stupid. I'm putting words in their mouth on that one, right? But that was part of the foundation of this case. That you have to make an offer. Well, let them put zero. And Bright MLS in the Northeast has had this policy for a while, and they saw no statistical change. Allowing the zero, they saw no statistical significant change to what the in offer of compensation was at closing compared to what it was before the policy change, right? Because
Right.
sellers generally do see, maybe not in these classes, but they generally do see the value in allowing the listing broker to compensate a buyer's broker that brings a qualified buyer that they agree to terms on.
Exactly. Yeah.
So,
Interesting stuff. I'm calling it a roller coaster ride. It's a lot's going to change in the coming months. I'm going to be keeping my eye on the Moehrl case when it goes to trial in the spring of 24. You said it was April? I think it's
I think it
April.
was
I think it's
March,
set for
April.
trial
Yeah,
in April.
yeah.
That one's going to be interesting because we saw how everyone reacted to this Missouri verdict, right? Now, if Moehrl comes down in favor of the plaintiffs, now we have empowered sellers, right? That
Mm-hmm.
side of the aisle, so to speak, not politically, but the people who agree with sellers that commissions are being artificially inflated here. Now they got 2 consecutive wins. But
Mm-hmm.
if Moehrl comes down the opposite way, or perhaps not with as much enthusiasm from the jury in that case, now we have a little bit more of a balanced playing field. Because remember, we
Break
have to look at what?
breaking news. Breaking news.
Oh
three
my God,
hours
you're
ago.
kidding me.
It looks like they're going to go to trial in the fourth quarter of next year now.
Moehrl?
Yeah.
Wow, you heard it here first, folks. So
Breaking news on the
okay, so
121% podcast. That's the extra 21%, folks.
awesome. Well, that's pretty cool that we found out right here live. Okay, so I'll still be watching that case
Yeah.
because what to me, what that tells that tells me, just kind of shooting from the hip here. That tells me that's 6 months more of settlement talks.
Mm-hmm.
That's 6 months more for these parties to resolve their cases, to resolve their claims against one another, avoid a potentially disastrous consecutive multi-billion-dollar verdict.
Mm-hmm.
And I think that's going to really change things. The Gibson case is going to be tremendous as well. One that I'm sorry I didn't cover that I'd like to close with, if we can,
Yeah.
is the case in New York City. This
Oh, yeah.
case has
That
been
one.
brought in New York City. This
Yeah.
basic claim has been brought in New York City, which, by the way, is some of the most expensive real estate in the world per square foot.
Yep.
So, I look at that New York City case as the other end of the spectrum, right? Missouri, breadbasket of the United States, middle income households, check for sellers.
Mm-hmm.
Moehrl opened the floodgates, right? Check. Then we're hitting South Carolina. Gibson covers the whole country. And now to bring it all home and tie it up in a bow, we got the case in New York City that's focused on Manhattan real estate sales, some of the most expensive sales, the biggest, most powerful brokerages, some of the most well-known TV personalities work for those brokerages.
Mm-hmm.
There's a reason that these cases came in sequential order like that. Not to say that it's a conspiracy on the part of the lawyers, but
Mm-hmm.
it's indicative of a shift. It's indicative of the attempt to really upend the industry. So all of these cases play their own role in seeing how the story unfolds.
And you also have the one in Texas from the QJ and 5 Points Holding or the plaintiffs on that one. So, have you heard about that
Oh,
one?
yeah.
Yeah.
Forgot about that one. I forgot about that
Yeah.
one. Yeah. Don't know too much
And
about
so,
that one, but yeah.
yeah. That one's gonna be an interesting one too, because it's coming at the there are a lot of small players there, so it wasn't as big as the bigger suits, right? They're going after some small, more regional players, Keller Williams side, Home Services, and Fathom. And then they're going after teams like the Loken Group, Hexagon Group as well. Like, so actually going after real estate teams as well.
That was the one where they named individual brokers as defendants, if I recall correctly, which is an important distinction, right?
Yeah.
Because all of these other cases, these are corporate liabilities. These are corporate defendants. The entities are the defendants. But here we're talking about allegedly intentional conduct by an individual.
Yeah.
And that's very different, because a judgment against an individual means that individual has to pay. Very problematic. That one's a little bit more concerning for me. The defense lawyer in me is like, oh, really?
Right.
That one. I don't know that there's necessarily. I don't know that there's necessarily facts, but I don't know enough about that case to express an opinion. But generally, antitrust violations don't occur at the individual level. It's usually at the corporate level.
Well, this has been a great chat. I've been looking forward to having this with you for a couple weeks now. And I would just say for all the agents and brokers, everyone out there is, take a breath. If you see something online, don't go straight to the keyboard. Do some research, verify facts from a couple different, reputable sources. Read the cases yourself, before you become a keyboard warrior. And just remember that it's not just your peers that are watching, it's the consumers. And if you don't think that DOJ and state commission and board folks are watching, you're crazy. They're watching too. So you want to make sure that, you're putting out that, don't add to hysteria, put out a professional image. If you want to learn about it and educate, make sure you're doing the facts. Just please, for our industry and for you, be responsible. So any closing thoughts on your side, Andrew?
No, just I'm going to be waiting. I'm going to be waiting and watching with bated breath, and I hope to run this back when we have a little bit more information here at the next major benchmark. I was hoping maybe March, April, after that case went to verdict, but I think we're probably going to see some movement here locally in the first quarter. Some sort of response after NARF gets their appeal filed and it works its way through. So I'll be watching, and I'm happy to run this back and do another industry update with you if you'll have me.
Get together after, of course, and get together after maybe the judge in the Burnett case passes his, or if he does have, pass any injunctive relief, we can kind of talk about that and what that means for the industry when that comes down.
Yeah, that'll be the canary in the coal mine, to use one of my many cliches I've used today.
I'm writing them all down. We're going to come up with a book, the agent's attorney cliches. So, well, everyone, thank you so much. You're watching on YouTube. Thank you for watching. Be sure to hit the subscribe button, click on the bell, so you can be notified when we do release future updates. And as Andrew said, we'll be back together to talk about this as it continues. If you're listening on your favorite podcast platform, please do us a favor and leave a review. That helps us get our message out to more people. And we'll be back regularly with updates on this and other topics that impact our real estate industry as a whole. So again, thank you so much for that. I can say that again. Thank you so much for watching the 121% podcast. Have a great day and be safe out there.